Shalom, Erev Tov from Jerusalem, Israel, and Boker Tov out there in California, and good afternoon in the Eastern Shore, and anywhere else you may be in. Wonderful to see you, wonderful to have you with us, and wonderful to be together once again for a Hiddush webinar, together with our co-sponsors, the American Association of Jewish Lawyers and Jurists, J-Plan, the Jewish Legal Pluralism Network, and Ruach Hiddush, Rabbis and Cantors for Religious Freedom and Equality in Israel. I am not sure, the screen doesn't show me who, everybody that's on the call, but I think I saw Mark Enshen, who is one of our co-chairs of J-Plan, and I mentioned before that we are privileged to have Richard Foltin, the executive director of the American Association of Jewish Lawyers and Jurists, with us. And I assume we have more colleagues, more rabbinic colleagues and activists in the field. And since I do see Shalom Schechter on my screen, he is one of those. And I think, Linda, behind you is another one of those who is both a lawyer and a rabbi. So it's one.
Nobody's perfect. Nobody's perfect.
Right. Okay, so we are here today because Hague calls us. The Hague calls us, and just a few months ago, we had a session with Alan Baker following the hearing that took place before the International Court of Justice in The Hague, and he explained to us what that was about and what transpired in the hearing, and how to make more sense of it. But now the whole picture has become further entangled. So we have asked Alan to be with us again, and he graciously agreed. Alan has been, going back before after he's making Aliyah from England, but the relevant chapters that I'm familiar with are his years of service at the International Legal Department of the Judge Advocate Division, and then the legal advisor of the Foreign Ministry of Israel, and then Israel's ambassador to Canada, and now with the
Jerusalem Center for Public Affairs.
Huh? Say that again?
Jerusalem Center for Public Affairs.
Right. And of course, what may be less relevant to the topic at hand, but very relevant to us at Hiddush, is that Alan is the chair of Hiddush Israel, Hiddush for Religious Freedom and Equality, and we are immensely grateful to him. So we spoke about the International Court of Justice in The Hague, and now we are confronting a new entity, and that's the International Criminal Court. And maybe before we go into a deeper presentation or a deeper exploration of the issues, we titled the topic today, the Hague International Courts, What, Why, and What Can We Do About It? So first of all, tell us the what. Why two courts? Are they connected? Are they coming under one umbrella? Are they somehow feeding each other? And what's their authority? And who put them there? And when did they go there? And how does Israel connect with these two courts? So first, the what?
Okay, what? The Hague International Courts, what, why, and what can be done about it? First of all, the what is the fact that there are two international courts in The Hague. The International Court of Justice, the International Court of Justice at The Hague is a UN organ. It was established together with the UN in 1945, and it's a court that's for litigation between states and for giving advisory opinions that are presented to it by other UN organs. So it's only between states. It doesn't deal with individuals. It doesn't deal with people. It's been in existence for a long, long time. And most states have accepted the jurisdiction of the court, which means that in the event that there will be some litigation between those states, then they've automatically accepted the fact that the court can come into their issue or their conflict and answer it. It usually deals with border problems, diplomatic issues. It's very rarely major political issues. But first and foremost, what we all have to understand is that it is a UN organ. And the UN is the UN is the UN. And it's influenced by the reports of the UN. It's influenced by resolutions of the UN. And its judges are appointed by their own countries. There are 15 judges on the basis of the UN geographical division of the world, which basically means that if you're not a member of any of the regional groupings of the world, like the African group, the Latin American group, the Eastern European group, the European group, if you're not a member of any of these groups, then you can't become a judge. And Israel is not a member of any of these groups, so Israel isn't entitled to have judges elected or appointed, even if at the best of times an Israeli judge were to be elected, which is highly unlikely. So the first thing that we have to understand is that this is a politically based court, as everything else in the UN. And this is what basically drives its functioning, especially with respect to the present case that's being presented against Israel. But before I go into that, let me discuss the other court. The International Criminal Court has got absolutely nothing to do with the International Court of Justice, apart from the fact that they're both in The Hague. The second court, I discussed the first court, the International Court of Justice, which is a UN body based on the UN politics, basically, whose judges are elected by their countries, most of whom receive instructions from their countries with respect to how to vote in the various cases. They're not supposed to, because they swear an oath of office undertaking to be completely unbiased and not to take any side. But as we've seen in the last few weeks, they vote in accordance with the positions of their respective governments. And the last thing I said was that because Israel is not a member of any of the UN regional groups, because basically UN is out of the possibility of being accepted in any of these groups, then Israel has got no chance of being elected or having a judge elected to the International Court of Justice. The present Israeli judge there is an ad hoc judge. Whenever there's a case involving a particular state, that state's entitled to appoint an ad hoc judge, which in this case is Judge Professor Aaron Barak, the former Chief Justice of Israel's Supreme Court. But these ad hoc judges don't have a vote. They can merely express their opinion. The second court in The Hague is the International Criminal Court. Now, this was established, the idea arose in the early 1950s by a number of Jewish international lawyers, Jewish and Israeli international lawyers, two of whom were Yaakov Robinson from the United States and Shabtai Rosen from Israel, the aim was to establish an international tribunal to deal with the most serious crimes against humanity, the most serious war crimes, and various other most serious offenses. It halted during the time of the Soviet Union, that vetoed basically any possibility of going forward. And when the Soviet Union disbanded, the group of states continued their act of drafting a statute for this new international court. And over the years, a number of international conferences were held in various places. And ultimately, in Rome in 1989, the statute of the new International Criminal Court was formally completed and signed, and a number of states became party to the statute. A number of states, serious states, haven't become party to the statute for basically political reasons, because as with everything, with every international conference, the problem was that politics were brought in to the drafting of the statute, and so the United States, China, Russia, Israel, and several other serious countries, all of which represent, I think, the majority of the population of the world, have not become party to the statute of the International Criminal Court. Now, how does the International Criminal Court work? Any state that is the statute of the International Criminal Court is limited to states, to some states only. Any state may present a complaint against the actions of any individual who's a citizen of another state party, and may also complain against an individual who may be present in the territory of a state party. And the court then goes into a procedure, a pre-trial procedure of considering whether the complaint is sufficiently grave in order to answer the criteria of gravity that the statute of the International Criminal Court requires, and also whether the court has a jurisdiction with respect to the territory involved. Now, if we're already dealing with the International Criminal Court, so I'll stick to this. Now, your question of why and how. So we've dealt with what. Now, why? As I said, the International Criminal Court is composed only of states. But because the Palestinians were upgraded in the United Nations, not to a full status of state, but to a permanent observer state, they took the word state and followed it through with the Secretary General of the UN, asking the Secretary General of the UN to accept them as a member state of the International Criminal Court, despite the fact that we all know that there's no such thing as a Palestinian state, and there's no such thing as sovereign Palestinian territory yet. It's all subject to negotiations that the Palestinians themselves have agreed to, together with the Israelis, on the permanent status of the territories. In the meantime, there's no Palestinian state that over which the International Criminal Court can exercise its jurisdiction. But this didn't prevent the Palestinians, nevertheless, over the years, since they achieved this upgrade, which was in 2012, and they joined the court in 2015, and the court enabled them to join based on political resolutions. Since then, they've presented hundreds of petitions complaining against various Israeli actions, which they term to be crimes against humanity, war crimes, genocide, in the hope that the court will accept the fact that they are a state and that it has jurisdiction over what they claim to be Palestinian territory. Over the years, these large number of complaints have been investigated, and the prosecutor of the court, or the various prosecutors, have transferred these claims to a pre-trial chamber in order to decide whether the court has the jurisdiction to deal with them. With respect to the present case, in fact, there are two cases. There's this one case that's being dealt with as a result of all these Palestinian complaints. But now the Palestinians came to the United Nations and said, well, we want the International Court of Justice to, the International Court of Justice to issue an advisory opinion as to whether Israel's settlement activity is legal or not. And of course, the International Court of Justice, being a UN body, immediately took it up, and it's presently in the process, in the beginning process of dealing with this. So the International Court of Justice has got two functions at the moment with respect to Israel. First of all, it's dealing with a complaint by South Africa claiming that Israel is committing genocide against the Palestinian people. And the second is the Palestinian request for an advisory opinion regarding the legality of Israel's settlements. Now, with respect to the, let's come back now to the South African prosecution against Israel. First of all, we have to understand what's behind it. And I think I explained this to you in our last meeting. What actually happened was that you probably know that in the last few days there have been elections in South Africa, and the African National Congress, while it won the elections, it didn't get the majority that it's always had since the end of apartheid. And so it has to form a government with other parties. Now, what actually happened was that the African National Congress went bankrupt. And the foreign minister of South Africa, who's the foreign minister of the African National Congress, was invited to Iran, to Tehran. And the Iranians promised to cover all their debts on the condition that South Africa institute a claim against Israel for violating the UN Convention against Genocide. And this is exactly what they did. Now, according to the UN, the jurisdiction of the court is only limited to the question of whether genocide is being carried out and whether there's an intention to commit genocide. The Genocide Convention requires these two elements only. The International Court of Justice isn't supposed to micromanage a war or a conflict. It's only supposed to deal with these two questions. And in the process of making this complaint, according to the statute of the International Court of Justice, the court can issue provisional orders if requested by one of the parties, pending the final judgment of the court, which can take several years. So what happened was last January, the South Africans requested provisional orders by the court to call upon Israel to end the fighting, and also to call upon Israel to stop inciting to genocide, and to call upon Israel to enable humanitarian assistance, and several other requests. The court considered this and decided that not to order the end to the fighting, because the court came to the conclusion that there's no intention, or there's no indication of a specific intention to commit genocide, and Israel isn't committing genocide against the Palestinian people. It's basically fighting in self-defense against a terrorist organization. But the court did issue temporary orders to enable an increase in humanitarian aid and to enable international organizations to function in the area. Now, the South Africans didn't like this, and they've come back to the court 3 other times, the latest one a week and a half ago, where they're asking again for the court to order Israel to cease its military action in the area of Rafah, which is a new area that Israel started dealing with since the last orders issued by the court. And the court, whilst it didn't order Israel to cease its action in Rafah, it did say that in carrying out its action in Rafah, Israel should ensure that it doesn't do anything that can be interpreted as being an act of genocide or an intention to carry out genocide. So basically, the court didn't change its original order. It just clarified it to a certain extent. But it did respond to a South African request to enable UN and international inquiry bodies to enter into the Gaza Strip. And this is something that it didn't ask for in the earlier orders, and Israel objected to this very seriously, and Israel has got no intention of enabling this, because the court in its orders has basically relied upon data and information emanating from UN organizations like the United Nations Refugee and Works Agency, which is an agency which has famously been caught out participating in the acts of terror by Hamas and participating in education programs inciting against the Jews, anti-Semitic incitement. So Israel's basic position is that it's not going to permit any of these UN organizations that are supplying the court with false information to come into the territory until there's an agreement between the parties to cease the fighting and to return the Israeli hostages. So this is where that stands at the moment. With respect to the International Criminal Court, the latest development is this, that as a result of these various complaints issued by the Palestinians, the court has been asked by the Palestinians to issue arrest warrants against any of the people involved in carrying out war crimes or crimes against humanity. And the prosecutor of the court came up with he gave an interview on CNN, which is in itself a very strange way of announcing this, that he said that he has requested from a pre-trial chamber that chamber issue arrest warrants against Israel's prime minister, against Israel's minister of defense, and against the 2 leaders of Hamas, Sinwar and Haniya, all of whom are bunched together for carrying out crimes against humanity, war crimes. Now, this created a huge shockwave because the prosecutor based himself on the conclusions of a committee of international lawyers composed of many lawyers who have openly announced their hostility to Israel, and it really went against what we all thought to be the professional behavior of this prosecutor, who up to now has been very careful not to take sides. And he's always been very cautious, and he came to the area and he interviewed the families of hostages, and he was always very cautious not to take sides. And all of a sudden, this announcement that came out of the blue of requesting arrest warrants is a bolt of lightning from the point of view of Israel. And we don't really know how to deal with this. Because, first of all, the court hasn't yet declared that it has jurisdiction over the complaints issued by the Palestinians. The UN itself has given its sanction to the Oslo agreements, whereby the Palestinian leadership and the Israelis agreed to conduct negotiations on the permanent status of the territories. So the Palestinians themselves are basically in conflict with their own position by, on the one hand, agreeing to the fact that only negotiations can solve the issue of permanent status, and on the other hand, claiming that they're a state and giving jurisdiction to the International Criminal Court to deal with Israeli leaders against whom complaints have been made. So this whole question of the request for arrest warrants is in grave legal doubt as to whether the prosecutor has the power, has the authority, and has the jurisdiction to do this, as long as there's been no determination as to whether the court has jurisdiction over territory that's not yet Palestinian, if it would ever become Palestinian. And the whole aim of the Oslo Accords, which are still very much valid, are to negotiate a permanent status agreement, which could be one state, two states, three states, federation, confederation, condominium, co-imperium, any permutation that could come out of these negotiations, and not necessarily the quote-unquote two-state solution that most Europeans and even the presidents of the United States, the present president of the United States, seem to have adopted blindly without really thinking what it means. So that's where we stand at the moment. I hope I haven't confused you all too much, but let me just respond to this one question that I have received. And perhaps I've already clarified some of these, even some of the answers to this question. Does the claim that Zionism is a colonial settler enterprise have anything to do with the view that the Hague courts are taking in addressing the current cases before them? So, because the Palestinians have issued a request for an advisory opinion on the legality of Israel's settlements, so this is an issue that's been taken up by the International Court of Justice. Does the claim that Zionism is a colonial settler enterprise have nothing to do with the view that the Hague courts are taking in addressing the current cases before them on Israel's responses to October the 7th? It's got nothing to do with it. The action by the International Court of Justice regarding the request for an advisory opinion on legality of the settlements has got absolutely nothing to do with the October the 7th tragedy, the brutal massacre, and what the ICJ, the International Court of Justice, has been asked to do is to determine whether Israel is carrying out genocide or intending to carry out genocide or not. So it's got nothing to do with that. The next part of the question was, has Israel called as witnesses Christian and Muslim clergy to testify that their own holy scriptures document that Jews were an indigenous population in Palestine well before the arrival of any ancestors of the current Arab population? Well, first of all, Israel is not a party to the International Criminal Court, and so Israel doesn't and can't make complaints. But that doesn't prevent individuals and Jewish organizations and other organizations from issuing complaints against Palestinians or anybody else committing violations of the laws of armed conflict, humanitarian law, etc., etc. And several Jewish organizations have already issued complaints against the leaders of Hamas for carrying out these violent crimes, rape, murder, torture, kidnapping, and several others. These are all prohibited by the statute of the International Criminal Court. But since Israel is not a party to the statute, so Israel can't send witnesses as such. With respect to the International Court of Justice, the complaint regarding genocide, so the court doesn't hear witnesses. Israel has presented its case. The court is now supposed to consider the positions of both sides and ultimately come to a judgment, which, as I said, can take years. And in the meantime, the South Africans are still trying to force the court into becoming a micromanager of Israel's military actions, which Israel obviously is objecting to. And if anybody wants to read a correct legal position, then try and get into the website and read the opinion of the Ugandan judge, who is the deputy president of the International Court of Justice, on what she wrote with respect to the South African case. Also, the opinion by Judge Aaron Barak, who obviously came down against this. One other point, and then I'll open it up for questions. As I said, the International Court of Justice is a UN body. It's composed of judges appointed by their own states. The president of the UN court for the last month has been a Lebanese international lawyer. Now, funnily enough, or strangely enough, despite the fact that the present case involves Israel, to which Lebanon is in a state of, with which Israel is in a state of war, and despite the fact that this same president, before he was president, was their ambassador to the UN, and he came out with very nasty statements accusing Israel of apartheid and various other crimes. The natural assumption will be, in accordance with the statute of the International Court of Justice, that he would remove himself from the panel of judges for bias and for having taken a position. And he didn't do this. And this is indicative of the politicized nature of the International Court of Justice. And this, no doubt, will have repercussions in future cases if states decide that they want to accept the jurisdiction of the court that's proving itself to be a very much politicized court. So, as you can see, this is these are two separate issues that are being dealt with. Everything is still going on, and as I said, who knows within the next 2 or 3 weeks whether arrest warrants will be issued or not. I would gamble on the fact that they won't be issued, but I may be naive. And whether the court will sit on its advisory opinion with respect to the legality of Israel's settlements. And there are many documents that have been presented by various organizations arguing with this assumption. And by the way, when I say assumption, I mean that the mandate given to the court basically assumes that Israel is in violation of international obligations. It doesn't ask the court whether Israel is. It says, is it true that Israel is in violation of its international obligations because it's maintaining a prolonged occupation? By the way, there's no such thing as a prolonged occupation. An occupation is a perfectly legal term of art in international law, and it's permitted according to the laws of our own country. There we are. I hope I haven't complicated you too much.
Thank you, Alan. Look at the other questions that were posted. And in the meantime, Richard, if you'll unmute yourself, and if you are still on the train and you are still in a condition that enables you to participate, Richard, I know that you have had quite a bit of experience in international law. So would you like to make any comments before, while Alan is looking at the other questions?
Well, you're giving me far more credit.
I can't see the other questions. I'm sorry.
In the chat, you don't see?
Oh, I don't see. Oh, wait a second. Yes, two.
Yeah, okay.
Okay, I'm listening.
So
Okay,
Alan,
go ahead.
you look at it, and we'll listen to Richard for a couple minutes.
Okay.
Yes.
Well,
Richard, go ahead.
Rav, you're giving me far more credit than I deserve. But let me just ask if Mr. Baker knows what the posture of the United States has been on these questions of the jurisdiction of the ICJ and the ICC. The United States, of course, itself is not a signatory to the ICC, and that would be problematic for the United States, were Israel to be considered subject to the jurisdiction of the ICC in circumstances.
Okay, well, the answer to that is basically that the United States, not being a party, objects to all these actions by the Palestinians. It objects to the fact that the ICC accepted the Palestinians as a member state, while it's not a sovereign state. And the United States, and by the way, also the British and other major countries also agree that these complaints by the Palestinians have no legal basis and don't give the court jurisdiction.
Anything else, Richard?
Okay.
No.
All right.
My connection is not very good. So
thank you.
Thank you.
And okay, I know that Mark Enchen is with us on the call. Mark is a co-chair of JPLAN, the Jewish Pluralism Legal Action Network. Mark, you served with the Canadian Foreign Ministry. I don't know whether you were exposed to any of these issues during the years that you served there. Do you want to make any comment or say anything to Alan in following his presentation?
Well, I just would reiterate what Alan said in terms of the political.
Can you get closer to the microphone?
Yeah, can you hear me now?
Yes.
So I would just echo what Alan was saying in terms of the political environment of the United Nations. I served at the UN in 1976, 1977 on the Canadian delegation to the General Assembly, and it turned out that I was responsible for all of the Middle East issues on the agenda of the General Assembly each year as the junior advisor. And I was required to sit there and work through about 20 different resolutions on various Middle East Israel questions, providing explanations of vote when Canada voted and writing speeches for our delegates and so on. And the political framework in which all this took place was that it was all one-sided. It was, and it permeates not only the courts, as Alan's indicated, but I think it permeates through the General Assembly and through the specialized agencies of the UN as well. And we can see that in the Human Rights Council and in other specialized bodies of the UN, where the chairmanship of various bodies is given to states which have anything but a human rights stellar record, and this has just continued the politics of the organization. And I think what troubles me now more than ever over many years of sort of observing this since I was in the Foreign Service is that our Western democratic countries, my country included, Canada, do not seem to want to stand up and really take principled positions and try to put a stop to any of this in any way that they can. And
well, Mark, it all depends who's the Prime Minister of Canada. The former Prime Minister Harper took very serious positions in support of Israel. The present Prime Minister doesn't.
Right, but I'm talking about our positions at the UN in terms of really standing up and trying to in the political nature of the United Nations, what goes on in General Assembly, specialized agencies, regardless of the government in Canada, we don't tend to be as vocal and as aggressive as I think we should be, and as I think other Western democratic nations ought to be. And particularly when you consider that the funding of the United Nations and its specialized agencies, for the most part, comes from these very countries and not from the third world countries or from the non-democratic countries. They do pay a little, but nothing compared to what Canada, the US, Australia, New Zealand, Great Britain, France, and others pay.
Okay, can I deal
Thank
with
you, Mark. Alan, can you shed some light, following what Mark was saying, can you shed some light on who is with us and who is against us in terms of countries that took a stand, either by joining the South African prosecution or by standing with Israel?
what's that? I didn't get that.
I'm saying, can you shed some light on who is with us and who is against us in terms of countries that took a clear stand, either by joining the proceedings on that South Africa started in the International Court of Justice, or countries that have clearly stood with Israel in rejecting
Prosecution.
the impression that what Israel is doing is in any way, shape, or form connected with genocide.
You know what? I really don't remember the 2 or 3 countries that requested to join South Africa in this claim, but it's only 2 or 3 countries, and I think it includes Mexico, but I'm not sure. Which is interesting now that there's a new president of Mexico.
A new president.
There's a question here.
We should indicate that the new president, she's also Jewish.
I know, but she's not known to be very sympathetic to Israel.
No.
There's a question from Shalom. Now that the UN has voted to recognize Palestine as a country, does the International Court have jurisdiction over Palestine and furthermore over actions of the authorities in Gaza? No, look, the recognition of Palestine in the UN is a non-binding automatic majority vote that has got absolutely no legal authority. It's purely symbolic. The UN hasn't got the authority to establish or recognize states, and it can only accept states as members of the organization upon a recommendation of the Security Council. And the Security Council is not prepared to make this recommendation, especially in view of the fact that the United States has vetoed it. And if it weren't for the United States, then probably others would veto it, because there's no, the Palestinians don't answer the basic criteria, international criteria for statehood, which means that they have to be peace-loving. It means that they have to have full authority over all their territory, which is not the case. It means that they have to have a basic common language, which is the case. And it means that they also have to be capable of carrying out international obligations, which they are not. So the UN vote to recognize Palestine is purely symbolic and doesn't make any difference whatsoever. How is it that a state can be a member of the UN but not admitted to one of the regional groups? A good question. The Article 1 of the, 1 or 2 of the Charter of the United Nations requires all states to enjoy sovereign equality in the organization. And the only state that doesn't enjoy sovereign equality is Israel. The reason being that the UN is divided into international groupings, and the Arab or Western Asian group decided not to enable Israel, despite the fact that geographically it should be in that group, not to enable Israel to be a member of the group. Therefore, Israel can't have consultations with members of the group. Israel can't ask for recommendations or proposals for submitting candidatures for various UN organizations. And basically, Israel is blocked. So what did the Europeans, the Western Europeans and others do, including the Americans and the Australians? They came to Israel and said, look, we'll offer you a deal. We'll allow you to consult with us on various issues that are on the agenda of the UN, but you won't be able to put up candidacies for the Security Council and for the International Court and various other bodies. You might be able to do so, but you'll have to join a long line of states which runs to 12, 15 years. So basically, it is a fact that Israel is a member of the UN since 1949, but it has never been admitted to any of the regional groups and therefore is discriminated against. Israel claims this every year at the General Assembly, and every year nobody takes any notice of it. Shalom's next question is the ICC required to defer any actions until it is seen whether the country in question can deal with the accused in a manner that respects judicial norms, and if so, to decline to take action themselves? Good that you asked this question, because it enables me to go further or deeper into the kishkis of the International Criminal Court statute. According to the statute, if a country has a capable, free, independent judicial system and is willing and able to try any complaints against particular individuals under its jurisdiction, then the ICC can't have jurisdiction over that complaint. So as long as Israel can prove, and it doesn't really have to prove it because the Israeli legal system is widely acknowledged to be one of the most advanced legal systems in the world, and even the Canadian Supreme Court has consulted with Israel's Supreme Court on various issues. When I was ambassador, there was a huge delegation of Israel's Supreme Court justices that came for long meetings with the Canadians. So that's another puzzling thing, the fact that because Israel does have the capability of conducting its own legal inquiries and legal cases, then the system of complementarity exists, and the ICC can't really deal with it. So why then has the prosecutor asked for issuing of arrest warrants? This is another problem that I presume that the prosecutor himself is going to have to deal with it. And hopefully the judges, the three judges of the pre-trial chamber, will point this out to him, that Israel is not a kangaroo court, or is not a, Israel has a very, very advanced system of law. Next, Shalom. In response to the South African request, has Israel or anybody else asked the court to demand that Egypt open and maintain humanitarian corridors for aid? The answer is yes. The court, in its latest order, asked for the Egyptian crossing point in the Rafah area to be opened. Israel has been begging the Egyptians for weeks to open it, and they've refused. So in the last couple of days, there's been an agreement between Israel and Egypt to enable the Rafah crossing to be open. And so whilst the court directed its order against Israel, Israel has never prevented the crossing from being open. It was always the Egyptians. And also demand that Hamas stop hijacking international aid, and demand that Hamas grant immediate access to the ICRC to all the remaining hostages. Well, these are two very sore points. It's common knowledge that the Hamas have been hijacking international aid and using it for their own purposes and selling it on the open market. And the markets in the Gaza Strip are packed full of products that have been stolen from this international aid. But nobody seems to really be bothering with this, and even the International Court hasn't really taken into consideration the fact that Israel did mention this in its initial response. The demand that Hamas grant access to the ICRC for the hostages, this is a very, very sore point. The ICRC has never even tried to get access to the hostages. And therefore, Israel has got a very, very huge complaint against the ICRC for simply not fulfilling its function. And when we see the ICRC being involved in transporting those hostages that are released, to me, it's pure hypocrisy on the part of the ICRC. They're not doing anything. They didn't even transfer medicine to Hamas to enable Hamas, or so that Hamas could give it to the hostages. Any medicine that possibly did get in was never transferred to the hostages. So the answer to that, Shalom, is a very big no, a very angry no. Lainey Bergman, have another commitment. Oh, sorry.
No, but Ariel Stone asked a question that
You
Mark
recognize the state of Israel. Of course you recognize. In order to enable Israel to be accepted as a member, the UN isn't meant to recognize. The UN accepted the recommendation of the Security Council to invite Israel to become a member in 1949. The fact that Israel is discriminated against is a violation of the UN Charter, but Israel is supposed to be a full member of the UN.
All right. Is there any happy note that you can think of to leave us with?
Sorry, I just wanted to add something. Alan, I think Ariel her question had to do with what happened in 1947, and my clarification was the partition resolution of 47 wasn't an actual recognition of either Palestine or Israel at that point. It was to recognize the creation of two states.
Yeah. No, again, it was a political, non-binding recommendation of the General Assembly, which Israel agreed to, and the Arab states rejected and immediately invaded the new state of Israel. So it was never a political form of recognition by the UN. As I said, the UN doesn't have the power to do this. But, and also the issue of two states, it didn't specify where these two states specifically would be, and as it was rejected by the Arabs, it never entered into force, in fact. So it became a dead letter from the very first day, despite the fact that the Israelis accepted it, even though Eilat and the southern part of Israel wasn't included.
Alan, any final words?
Just a second, there's another. ICRC claims that they are doing whatever they can to get access to the hostages. Excuse me if I don't say what I think.
Yeah,
I'm very familiar with the Red Cross. I've been active in drafting Red Cross conventions for many years, and in being there and in negotiating with them, and they're just hypocrites, and they're not doing their job. And in my view, something should be done to censor them, because they're really, the fact that these hostages have been there for 8 months and they haven't done anything to help them, and they're claiming that they're trying to get out of it, is a load of rubbish. That's it, folks.
Alan, any final words? And maybe final words with regard to what can be done about it?
What can be done about it? Look, what can be done, everybody is trying to do. And the issue at the moment is whether there'll be some type of agreement which will enable the hostages to be freed, and will satisfy Israel's need to get rid of Hamas as a body that can exist in the Gaza Strip, especially in view of the fact that it's promising to continue doing what it did on the 7th of October again and again. So Israel is in a very difficult situation, because on the one hand, it can't agree to the continuation of any Hamas influence in the Gaza Strip, but at the same time, it has to get back its hostages. And so Israel has got a huge dilemma, and this is what will play out in the next few days. And the Israeli population is completely in conflict with itself because of this.
Rabbi Shira Stern makes a point of clarification. She says, I agree completely regarding the International Red Cross, but the American Red Cross is a different story.
Well, you know, I'm surprised that the American Red Cross, the British Red Cross, and various other Red Cross, National Red Cross organizations haven't been more vocal from the very beginning, from the 7th of October. Why didn't they condemn the atrocities that took place? Why did they do nothing? Why didn't they petition the International Red Cross?
So,
I
Rabbi
have no
Stern,
answer.
do you know, you can open your mic, but do you know something specific about the American Red Cross that we may not be aware of? Shira? I can't open my mic. All right. That's for a rabbi, that's a professional, I don't know.
Good answer.
All right. So actually, Shira, if you know something about the American Red Cross that you feel we should be sharing with the people who registered for this webinar, send it to me and I'll gladly include it in the follow-up. Hold down your spacebar. All right. Well, that's practical advice. Shira, is that the problem or?
In any event, folks, I have to leave.
All right. So, as I said, on June 25th, we will go into a deeper legal analysis for lawyers only.
Well, I don't know whether you need any deeper legal analysis, because this has been quite a deep analysis, but we'll play it by ear.
Sorry, say that again.
I don't know whether you need a deeper analysis, because this analysis that we've had over the last hour has been pretty deep.
Well, we shall see. And I assume that by then we may have also a decision by the International Criminal Court. It's possible, but we'll consult about that. For the time being, we are going to have a follow-up meeting with Alan for lawyers on June 25th. Alan, you have made things far clearer, even for me, that I've been following the news, and I'm sure that your comments were enlightening for many on this call who may have had less exposure. So thank you very much. You certainly took a complex situation, a troubling situation, and while it may remain troubling, at least we have a better understanding. So thank you all for joining us, and thank you, Alan, for being so gracious in responding to our requests. And shalom, and as we all feel and call for, we hope that maybe the signs of a possible agreement may lead to bringing home our hostages. So bring them home now, we hope, pray, and call. Toda rabba and shalom from Jerusalem.
Thank you, Ori and Ellen.
Thank you, Linda.